Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome back to Talk Law Radio. I'm Todd Marquardt. We're here on 9:30 a.m. The Answer and also podcasts everywhere. You can also find us on Facebook Live, on YouTube, or www.talklawradio.com. Today we're talking about elder law and nursing home Medicaid benefits to pay the high cost of nursing home care. And I'd like to offer a free book called Mamba Mentality, How I Play by Kobe Bryant, because Kobe Bryant is going to be the subject of our legacy segment at near the end of the show, and I'm going to be reading this book because I read about it online, and so you can read it too. Just give us a call and ask a question about elder law or nursing home Medicaid, and we'll send you a book. Okay, before the first break, I was talking about Medicaid applications and Medicaid appeals. I learned about a court case against Health and Human Services Texas, and so I want to share that with you now. It's Health and Human Services versus Maroney. The plaintiff was actually Anna Maroney, and she sued Health and Human Services because they denied her application, and went through the course of several appeals, and one court decided that, Health and Human Services was wrong. They wrongly denied Miss Maroney's Medicaid application. So what happened? Anna Maroney had a debilitating stroke, and that's why she needed nursing home care. And she didn't have high income. She didn't have a lot of money. Her treating physician described her as totally incapacitated and incompetent, and lacking the ability to manage her affairs from the date of her admission to the hospital. And so, like I said before, she applied for Medicaid. Health and Human Services denied her application, and she appealed. One district court reversed the denial, and Health and Human Services appealed that decision. And so I'm reading from this other court decision, and I'll tell you who won in just a minute. The issue was whether assets should be considered countable resources used to calculate eligibility when Ms. Maroney was incapacitated and had no agent under durable power of attorney and had no guardian. Well, here's some relevant law that you would want to know. Well, there's regulations in the Texas Administrative Code that lay out the eligibility requirements, the criteria for getting approved, and then there's federal regulations as well. And the general rule is that the state regulations cannot be more restrictive than the federal regulations. They can be more liberal. They can grant benefits to more people, but they can't make it more restrictive. So the framework for Medicaid regulations is in the Code of Federal Regulations, but each state is free to experiment with different ways of interpreting those regulations. And so the state of Texas has their regulations codified in the Texas Administrative Code. Okay, so let's go back to this case about what happened. Well, I'll tell you who won. Miss Maroney won. The court said that they should not have denied her benefits by counting assets that she had when she was incapacitated, but without an agent under power of attorney or a guardian, because there's a rule that says if, well, I'll just find it here. I'll find it here. So Miss Maroney had life insurance with cash value. And so the cash value of a life insurance policy counts against you. It's a countable resource. And if it's valued above $2,000 in adding up all of your countable resources, then you're not approved. But the court said assets should not be deemed resources, countable resources, given Miss Maroney's incapacitated state and the fact that no one else could liquidate the insurance policies. The reason it was difficult for a guardian to be appointed was because of some changes in the law in 2015. In 2015, the Texas legislature added an additional requirement when somebody's applying for guardianship. It requires an attorney or guardian ad litem to explore all alternatives to guardianship upon filing a petition. And so it took some time for the guardian ad litem to explore whether there was another way to get the cash out of the life insurance policy for Miss Maroney. The commission calculated, the Health and Human Services Commission calculated that the value of Miss Maroney's assets was about $7,000, and so that was over $2,000. So that's why they said she was denied benefits. Another rule in guardianship court is that the court may only grant the petition appointing a guardian if clear and convincing evidence reveals that alternatives were explored and deemed not feasible. And so that's why it took a long time for the guardian ad litem to find out whether there were feasible alternatives. So here's the rule on whether assets or resources should be countable or not. Assets are only countable resources if the applicant for benefits or a representative for the applicant has the right, authority, or power to liquidate those assets. So that's a rule based on the federal regulations and also the Texas Administrative Code. If a property right cannot be liquidated, the property will not be considered a resource. So that's why the applicant's representative thought that she would be approved for Medicaid benefits because of that rule. And the Health and Human Services Commission didn't see it that way. They just figured that it was a countable resource because it was cash value life insurance. The court said that implicit in the probate court's finding of incapacitation is that Maroney totally lacked capacity to manage her property. So that's another requirement for a guardian to be appointed, is that the judge has to find that the person is totally or partially incapacitated. So this court reasoned that because the court did find her to be totally lacking in capacity, she therefore had no power to liquidate her assets until the probate court appointed a temporary guardian or a permanent guardian. In this case, it was a temporary one because all the guardian needed to do was cash in the life insurance policy and spend the money on medical bills that the applicant owed. So the court said it's undisputed that Ms. Maroney could not liquidate those assets. So this case is a good tool to use if you're trying to help somebody get qualified for Medicaid benefits to pay the high cost of nursing home care, but the person's incapacitated and doesn't have a power of attorney or a guardian. The other lesson is that everybody should have a power of attorney, and you have to get one before you have a stroke or a heart attack or are otherwise rendered incapacitated, because you have to be able to sign it and you have to be able to understand what the power of attorney is. And so you have to have mental capacity to understand. And so we should all do one when we're healthy, even if we think we're never going to be unhealthy. So that's a good thing to ask your elder law attorney about, or your estate planning attorney, how to get a durable power of attorney. And not all durable power of attorneys are created equal. Some are defective that I've seen, people coming in asking why the bank won't honor their power of attorney. And some just need to include more provisions. So just like any contract, a power of attorney could include more situations, more circumstances, or fewer circumstances. And so a longer power of attorney might include more circumstances. The other thing is you should get legal advice on the choices that can be made in a durable power of attorney. There's another court case that we're going to talk about where the agent appointed in the power of attorney acted outside of the authority that he was given in the power of attorney, and was prosecuted for a crime and sentenced to prison for that. And so we don't want that to happen to good people listening to Talk Law Radio. So I'm here to help you discover your legal issue blind spots. So you're listening at the right time and at the right place. And if you call and ask a question about elder law, power of attorney, guardianship, or Medicaid today, the next caller will receive a book by Kobe Bryant, the famous NBA basketball player who wrote Mamba Mentality, How I Play. I haven't read the book yet, but from what I read online, it sounds like a good book. And if you want to learn about Kobe Bryant's mentality, that would be a good place to start. We're about to take a break, but before we go to a break, I want to talk about qualified funds or retirement funds or tax-deferred funds. These are all a type of resource that may or may not be countable when you're applying for Medicaid. So the shocking truth is that some people can qualify for nursing home Medicaid even if they have an IRA with lots of money in it. So if you're in a situation where you know somebody who needs help applying for Medicaid, or who has not yet applied for Medicaid because they think that the money in their IRA is going to cause them to be disqualified, have them call an elder law attorney. Got to take a break. When we come back, we'll be talking about saints and sinners. So stick with us.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Each week, attorney Todd Marquardt talks about the law. His mission with the Talk Law radio show and podcast is to help you discover your legal issue blind spots. In the beginning, God had one law. Don't eat from the fruit of that tree. Then came the 10 Commandments. Now we have federal, state, and municipal lawmakers that won't stop creating new laws. Laws that might impact you without you knowing it. Listen to the show and drop a line on Facebook or email host@talklawradio.com and let the host know what you think of the show, the topics you want to hear, and whether you want to be a guest.